Good day to everyone. In this video, we are going to discuss the difference between the crimes of murder and homicide. I know a lot of you already have an idea what these crimes are, in that both these crimes involve the unlawful killing of another person. But we will delve further into what murder is and what homicide is, so that at the end of this discussion, you will be able to cite the differences between the two crimes. First, I'm going to read to you the provision on murder, which is Article 248 of the Revised Penal Code. Any person who, not falling within the provisions of Article 246, shall kill another, shall be guilty of murder and shall be punished by reclusion perpetua to death if committed with any of the following attendant circumstances. Number 1, with treachery, taking advantage of superior strength with the aid of armed men, or employing means to weaken the defense, or of means or persons to ensure or afford impunity. Number 2, in consideration of a price, reward, or promise. Number 3, by means of inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment or assault upon a streetcar or locomotive, fall of an airship, by means of motor vehicles, or with the use of any other means involving great waste and ruin. Number 4, on occasion of any of the calamities enumerated in the preceding paragraph, or of an earthquake, eruption of a volcano, destructive cyclone, epidemic, or other public calamity. Number 5, with evident premeditation. And number 6, with cruelty, by deliberately and inhumanly augmenting the suffering of the victim, or outraging or scoffing at his person or corpse. This time, I'm going to read to you the provision on homicide, which is Article 249 of the Revised Penal Code. Any person who, not falling within the provisions of Article 246, shall kill another without the attendance of any of the circumstances enumerated in the next preceding article, shall be guilty of homicide and be punished by reclusion temporal. But before citing their differences, let us first discuss their similarities. First similarity for both murder and homicide: the victim must be a person. The term person here refers to the natural person, a human being, regardless of gender, race, or nationality. However, the person who is killed must not be the father, mother, or child of the killer, whether legitimate or illegitimate. Or the person who is killed must not be the legitimate other ascendant, like the grandparent, or legitimate other descendant, like the grandchild of the killer, or of the offender or perpetrator. Or the person who is killed must not be the legitimate spouse of the killer. Otherwise, the crime will be parricide, not murder or homicide. What I'm trying to say is, if the victim killed is the father, mother, or child of the offender, or the grandparent or the grandchild of the offender, or the legitimate spouse of the offender, then the crime will not be categorized as murder or homicide, as the case may be, but it will be categorized as parricide, because what is taken into consideration here is the relationship between the offender and his victim. Also, the person killed must not be an infant less than 3 days old, or less than 72 hours from the time of the child's birth. Otherwise, the crime will be categorized as infanticide, not parricide, murder, or homicide. Here, what is taken into consideration is the age of the child, not the relationship of the child with the offender. So even if it is the parent who kills the infant, the crime will still be categorized as infanticide and not parricide. Question: what if the offender kills his own brother or sister? Will that be considered as parricide? No, because siblings are not in the enumeration of who are the victims in parricide. And if you notice, except for the spouse, all the other victims in parricide are relatives of the direct descending or ascending line, not in the collateral line. Brothers and sisters are relatives of the collateral line. Second similarity for both murder and homicide is that a person is killed. The term killed means someone or something has caused the death of a person. Here, the victim must be killed to consummate the crime, because if the victim is not killed, the crime is only attempted or frustrated murder or homicide, as the case may be. Third similarity for both murder and homicide is that the accused killed such person. To kill means to cause the death of a person. Take note that there must be proof as to the identity of the offender, because if the witnesses for the prosecution is not able to prove the identity of the killer or the perpetrator, then there will be no conviction for murder or homicide, as the case may be, because the accused is not identified. Also, there must be proof of intent to kill. Intent to kill meaning that the offender intended to kill his victim. The death of the victim does not necessarily mean that the offender intended to kill the victim, because such death could have been caused by means of culpa or fault. What do I mean by this? Please remember that felonies in the revised penal code are committed not only by means of dolo or with deliberate intent, but also by means of culpa, which means by fault. And there is fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. For example, X forgot to unload the last remaining bullet from the cylinder of his caliber .38 revolver. As he was cleaning the same, he accidentally pulled the trigger, causing the gun to fire, hitting and killing his brother Y in the process. Question: was there intent to kill on the part of X? What do you think is the answer here? The answer is no. The killing of Y was the result of imprudence and or negligence, as X did not exercise due care when he cleaned the revolver without first seeing to it if the cylinder was empty. It was not the result of a deliberate act. Since there was no intent to kill, X can only be held liable for reckless imprudence resulting in homicide. In the case of Rivera versus People, the Supreme Court had occasion to state that intent to kill is only presumed if the victim, number one, dies, and number two, the death was a result of a deliberate act of the offender. So it is not enough that the victim dies. There must be proof that his death was due to the deliberate act of the perpetrator. For example, X aimed and fired the gun at Y, resulting in the latter's death. Here, intent to kill is presumed not only because Y died, but also because X deliberately aimed and fired his gun at Y. If there is no proof of such deliberate act, like for example, no one saw X aim and fire the gun at Y, meaning walang nakakita, walang witnesses, X cannot be charged nor be held liable for the death of Y. In the case of Edenitino versus People, decided on February 7, 2018, the Supreme Court said that intent to kill must be proven in a clear and evident manner so as to exclude every possible doubt as to the homicidal intent of the aggressor. Question: paano fiscal kung hindi namatay yung biktima? How is intent to kill determined? Answer: the following factors are considered to determine the presence of intent to kill. First factor is the means used by the offender. For example, did the offender use a gun, a knife, or a blunt weapon when he attacked the victim? Or did the offender only use his fists in attacking the victim? Those are questions that should be asked. Kasi malalaman natin dun sa means used if the offender really intended to kill the victim. Kasi for example, pag baril ang ginamit, the use of a gun, aiming it and firing it at another person will logically lead to the commission or infliction rather of injuries that could kill the person. Or the use of a knife and the infliction of the injuries by stabbing the victim with the use of a knife could logically result in the death of the victim, but not when mere fist blows are used. Those are the questions that should be asked when talking about the means used by the offender. Another factor is the nature, location, and number of wounds sustained by the victim. Questions such as whether or not was the wound fatal, non-fatal, or merely superficial, or questions such as where was the victim hit, or how many gunshot wounds or stab wounds did the victim sustain. The answers to these questions will help the prosecutor or the judge in determining whether or not there was intent to kill on the part of the offender. Another factor is the conduct of the offender before, at the time, or immediately after the infliction of the injuries. Questions such as what did the offender do or say prior to, during, or after the attack? Did the offender say something that would show his intent to kill? Did the offender, after delivering the first blow, immediately leave the crime scene without seeing to it if the victim has died? Another factor is the circumstances under which the crime was committed. Like for example, was the accused merely defending himself from the complainant's unlawful aggression or aggression? Because if the accused was merely defending himself from the unlawful aggression of the complainant, who turned out to be the victim because the victim got killed, then the accused will not be held criminally liable because that will become a justifying circumstance. The justifying circumstance of self-defense. Or you can also check into the motives of the offender. For example, the victim was suspected by the offender of killing his brother. So there was reason, or there is reason, on the part of the offender to attack and inflict injuries or cause the death of the victim. So a combination or a totality of these factors will help the prosecutor or the judge or any person for that matter to make a reasonable conclusion whether or not there was intent to kill on the part of the offender. If, after considering said factors, intent to kill is not shown, then the offender should be held liable only for physical injuries, not attempted or frustrated homicide or murder as the case may be. Example number 1. X repeatedly shouted, "I will kill you," but used only fist blows in inflicting injuries on Y. Here, there is no intent to kill because mere oral threats is not sufficient. X is liable only for physical injuries. So you can see from this example that there was no intent to kill because of the means used by X. He only used fist blows. Example number 2. X was attacked by Y with a knife. To fend off Y's aggression, X got hold of a piece of wood and struck Y's hand. As a result, Y sustained a broken hand. Here, X is not criminally liable. He was merely defending himself from Y's aggression. This is a classic example of the justifying circumstance of self-defense. Diba? I told you at the onset that murder or homicide involves the unlawful killing of another person. Self-defense, which results in the killing of another person, is not unlawful. Example number 3. X hired Y to kill Z. Pursuant to their agreement, Y, on the following day, fired several shots at Z, causing mortal wounds on his body. However, bystanders quickly rushed Z to the hospital, saving his life. Here, X and Y are liable for frustrated murder. X is liable as the principal by induction, while Y is liable as the principal by direct participation. Now, the crime is categorized in the frustrated stage because Y, the perpetrator, had already performed all the acts of execution which should have produced the felony of murder as a consequence. But nevertheless, the felony of murder was not produced by reason of a cause independent of the will of Y. And what is that cause independent of the will of Y? The act of the bystanders in quickly rushing Z to the hospital. Z could have died because Z had already sustained several shots from the firing of the gun by X. So, had it not been for the quick action of the bystanders, Z would have died. Now, the next question to ask is, bakit frustrated murder? Bakit hindi frustrated homicide? The answer to that is, there is this attendant circumstance or qualifying circumstance of inconsideration of a price, reward, or promise. The act of X in hiring Y for a price is that qualifying circumstance. Without that qualifying circumstance, the crime would have been only frustrated homicide. But because of that qualifying circumstance, which is in consideration of a price, then the crime becomes frustrated murder and not just frustrated homicide. Example number 4. X and Y had a heated argument, as a result of which X stabbed Y, hitting the latter on the arm. X could have delivered another stabbing blow on Y, but X instead threw the knife and ran away. Here, X is liable only for physical injuries. X is not liable for attempted homicide because of his spontaneous desistance. Now, if you remember, there is an attempt when the offender commences the commission of a felony directly by overt acts and does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his spontaneous desistance. Since X here in this example spontaneously desisted, meaning to say X was not able to perform all the acts of execution, not because of some cause or accident, but he was not able to perform all the acts of execution because of his own spontaneous desistance. And as you can see in the example, he already had the opportunity, or he could have delivered another stabbing blow, but instead of delivering another stabbing blow, he threw the knife and ran away. That is an indication of his spontaneous desistance. And the effect of that is that the crime committed by X will not be deemed to have been committed in the attempted stage. Now, will X be liable for some other crime? Yes, but no longer in the attempted stage of the felony. And what crime is that? The crime is only physical injuries. Example number 5. X, using the cover of darkness, waited for Y at a dark portion of the alley. When Y was about to pass, X shot Y but missed. Here, even if Y did not sustain any injury, X is liable for attempted murder. Why should X in this example be held liable for attempted murder? X should be held liable for attempted murder because of the means used. And what did he use in his attempt to kill Y? He used a gun, although he missed because, as you can see in the example, Y did not get hit. And why should we categorize the crime as attempted murder and not just attempted homicide? The crime should be categorized as attempted murder because X employed treachery, and treachery is one of the attendant qualifying circumstances which will qualify the act as one of murder. But in this case, since Y did not die, then X will only be held liable for murder in the attempted stage. When you say treachery, what do you mean by that? Treachery, if you still remember, is the employment of means or methods which tend directly or especially to ensure the execution of the crime without risk to the offender arising from the defense which the victim might make. So as you can see in the example, X used the cover of darkness, and when Y was about to pass by the alley, he suddenly shot Y, only that he missed in his attempt to kill Y. What then is the difference between murder and homicide? The difference lies in the presence of any of the qualifying circumstances enumerated in Article 248 on murder, such that the killing is attended by treachery, taking advantage of superior strength with the aid of armed men, or employing means to weaken the defense, or of means or persons to ensure or afford impunity, or the killing is attended in consideration of a prize, reward, or promise, or the killing is attended by means of inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment or assault upon a streetcar or locomotive, fall of an airship, by means of motor vehicles, or with the use of any other means involving great waste and ruin, or the killing is attended on occasion of any of the calamities enumerated in the preceding paragraph, or of an earthquake, eruption of a volcano, destructive cyclone, epidemic, or other public calamity. Or the killing is attended with evident premeditation, or the killing is attended with cruelty by deliberately and inhumanly augmenting the suffering of the victim or outraging or scoffing at his person or corpse. Let me give you some examples. Example of treachery. X, to ensure the execution of the crime without risk to himself arising from the defense which Y might make, shot the latter suddenly and unexpectedly. Example of taking advantage of superior strength. X, a big man in his 40s, stabbed and killed Y, an 8-year-old girl. X's size and weapon gave him superiority of strength. But here, you must take note that there must be proof that X deliberately used his superior strength to kill his victim. Example of with the aid of armed men. X, with the help of his companions who were armed with knives, killed Y. Here, there must be proof that X deliberately sought the help of his companions in the killing of Y. Example of employing means to weaken the defense. X suddenly throws sand on the eyes of Y and thereafter stabs him. Example of employing means or persons to ensure or afford impunity. X, disguising himself as a Wi-Fi technician, was able to enter Y's house and once inside, hacked Y to death. Example of in consideration of a price, reward, or promise. X hired Y to kill Z. Y thereafter shot and killed Z. Example of by means of fire, poison, explosion, etc. X, in order to kill Y, set fire to the house where Y was sleeping, killing Y in the process. Example of on the occasion of inundation, shipwreck, etc., or of an earthquake, eruption of a volcano, destructive cyclone, epidemic, or any other calamity. X, taking advantage of the panic caused by a typhoon, whereupon he shot and killed Y while the latter was busy securing the premises of his house. Example of with evident premeditation. X decided to kill Y for ruining his business. The following morning, X purchased several bullets at a gun store and loaded the same into his caliber .38 revolver. When evening came, X went to Y's house and there shot and killed Y. Here, there was a sufficient period of time that elapsed from the plan to kill Y to the commission of the crime for X to dispassionately reflect upon the consequences of his act. Example of with cruelty. X cut the fingers of Y and stabbed his eyes with the use of an ice pick before killing him. Here, the act of cruelty must be committed while the victim is still alive, because if the act of cruelty is committed after the victim has died, then the qualifying circumstance would be outraging or scoffing at the person or corpse of the victim. So, as an example, X, after killing Y, cut off his head and limbs. Take note that if any of these qualifying circumstances attended the killing, even just one qualifying circumstance, the crime is murder. Now, if none of these qualifying circumstances attended the killing, then the crime is only homicide. If two or more qualifying circumstances attended the killing, even if only one circumstance is proved, the crime is still murder, because as I said, only one qualifying circumstance is enough. And the qualifying circumstance or the qualifying circumstances must be alleged, meaning it must be stated in the information. The information, I am referring to the case that is filed in court. Otherwise, if the qualifying circumstance or the qualifying circumstances are not alleged, the same will not be appreciated by the court even if proved by the prosecutor during trial. And in such a case, the offender will only be convicted or held liable for homicide.